is an introduction and first reading of an ordinance on revenue measure only, blah, blah, blah. Do I hear a?
Move to read by title.
Thank you. That's what I was looking for.
Second.
Is there a second?
Second.
Anybody opposed? Okay, Michael,
It's
could
a
you?
public hearing.
Yes,
No, but they can read.
All right.
you have to read it first before we open the public hearing.
Okay, introduction and first reading of an ordinance of the City Council of the City of Emeryville amending Section 3-1.104, revenue measure only, does not permit business otherwise prohibited, of Chapter 1 of Title 3 of the Emeryville Municipal Code, adding Chapter 28 of Title 5 of the and adding Chapter 28 of Title 5 of the Emeryville Municipal Code, prohibiting the establishment of medical marijuana dispensaries in the city of Emeryville, and amending Section 1-201, subsection E of Chapter 2 of Title 1 of the Emeryville Municipal Code regarding violations.
Hi, Michael.
Good evening, council members.
Thanks for holding out till 10 p.m.
Thank you. I'm Michael Gaina, Deputy City Attorney. In 2004, the City Council enacted a temporary moratorium on the establishment of medical marijuana dispensaries in the city. The moratorium was extended twice and is set to expire in August 2006, and no further extensions are permitted. The City Council is therefore asked to consider what sorts of regulations, if any, should be enacted regarding the establishment and operation of medical marijuana dispensaries in the city. An ordinance has been prepared which proposes to prohibit the establishment of any dispensaries in the city. The proposed ordinance would also update provisions of the business license and penalty provisions of the municipal code. For the remainder of my presentation, I'd like to give you a quick update on the state of medical marijuana laws, both in California and on the federal level, and a few important court decisions affecting medical marijuana. And then I'd also like to give you a brief update on how other cities cities and counties in California have enacted their own regulations regarding marijuana dispensaries and their experiences with dispensaries in their jurisdictions. So regarding the law, in 1996, the people of the state of California enacted Prop 215, which allows seriously ill individuals to obtain and use medical marijuana without prosecution under state laws regarding cultivation and possession. Thereafter, in 2003, the state legislature enacted SB 420, which provides for limits on the amounts of medical marijuana which could be cultivated and possessed by the patient and or his or her caregiver. SB 420 also established a medical marijuana ID program, which was designed to insulate patients and caregivers from arrest for possession and cultivation of medical marijuana under state law. I'll note that neither Prop 215, the Compassionate Use Act, nor SB 420 provided for the establishment of medical marijuana dispensaries. That issue, that is the question of dispensaries, was an issue that was left to local jurisdictions to regulate through their police powers. And in fact, SB 420 specifically provides that cities are allowed to enact laws which are consistent with the provisions of SB 420 and Prop 215. Meanwhile, on the federal side, the Controlled Substances Act provides that marijuana is a Schedule I substance, making it illegal to possess, cultivate, use, or distribute marijuana for any purpose. A series of federal court cases has highlighted the conflict between federal and state law. In 2001, the United States Supreme Court, in the Oakland Cannabis Buyers Club decision, ruled that there was no medical necessity defense for the possession of or use of marijuana under the Controlled Substances Act. Thereafter, in 2005, the Supreme Court again ruled in Gonzalez versus Raich that the Commerce Clause does allow Congress to prohibit the cultivation and use of marijuana which would otherwise be allowed under California law. The practical significance of that decision is that federal law enforcement officers may continue to prosecute federal drug laws against Californians who cultivate, distribute, or use medical marijuana, which would otherwise be allowed under state law. These federal cases did not explicitly preempt California law or strike down the provisions of SB 420 or Prop 215. However, I will note that because marijuana remains a Schedule I substance, after Gonzalez versus Raich, a dispensary which would ostensibly distribute medical marijuana would remain prohibited under the Controlled Substances Act. Recently, in 2005, a California Court of Appeal held that that cooperative medical marijuana distribution and cultivation is not a protected activity under the state provisions SB 420 or Prop 215. The court reasoned that the Compassionate Use Act was designed for individual use and cultivation and not the sort of mass cultivation or distribution to hundreds of patients that was seen in that particular case. So to summarize the status of law, state and federal law, regarding marijuana use, marijuana and medical marijuana dispensaries remain illegal under federal law. Under state law, the state allows for the individual patient and or his or her caregiver to use and cultivate marijuana under specific circumstances. However, the state law does not make any provision for medical marijuana dispensaries, the establishment or operation of those dispensaries. State law also allows local jurisdictions to enact laws that are not in conflict with the provisions of state law. Regarding how other cities have addressed the issue of medical marijuana, in their jurisdictions. As part of your staff report, there is a brief summary page which gives you a summary of how different cities have adopted regulations. A lot of cities have adopted moratoria, which is similar to the one that Emeryville currently enjoys, which for a temporary period of time prohibits the establishment of dispensaries. Other cities, such as San Francisco, Berkeley, and Oakland, allow dispensaries to operate pursuant to regulation, usually through their zoning or land use ordinances. And about 22 other cities in California have enacted an outright prohibition on dispensaries similar to the one that's being proposed to you tonight. Those cities that haven't allowed dispensaries to operate in their jurisdictions have sometimes reported adverse secondary effects from the operation of those uses in their cities. Secondary adverse effects can include the odor of marijuana either being grown or processed and traveling outside of the boundaries of the dispensary, a spike in crime, including theft, trespassing, violent encounters between dispensary employees and would-be robbers, making an attractive nuisance of the dispensary. Parking issues have also been reported, and loitering. Based on the above, then, staff believes that the most appropriate response would be to adopt the proposed ordinance prohibiting the establishment of dispensaries within the city. And this recommendation is based on three main points. Number one, the ability for the city to exercise its police power to regulate the health, welfare, and safety of its citizens and businesses as provided under California law. Number two, the continuing federal prohibition against the use and distribution of marijuana for any purpose. And number three, the secondary adverse effects of dispensaries as reported by other cities. What I'd also like to do is emphasize what this proposed ordinance does not do. The proposed ordinance does not prohibit an individual qualified patient or his or her primary caregiver from cultivating, obtaining, or using medical marijuana for that patient's own individual use. The proposed ordinance does not add or take away from rights which are already authorized by Prop 215 and SB 420. If enacted, the ordinance would simply prohibit the establishment of medical marijuana dispensaries in the city. And as noted above, state law does not provide for the establishment of these dispensaries, while at the same time federal law prohibits such businesses outright. If, on the other hand, the City Council decides not to prohibit dispensaries in Emeryville, then the council is nevertheless asked to adopt the proposed ordinance while staff drafts regulations for your further consideration. Enacting the ordinance now would allow staff the opportunity to propose new guidelines for the operation and regulation of those dispensaries consistent with your direction. Adopting the proposed ordinance tonight would avoid the situation where you have the establishment of a dispensary after the expiration of our moratorium, but before we can enact new regulations for the regulation of those dispensaries. That's the conclusion of my staff report, and I'd be happy to take questions.
Are there questions at this point from council? If not, I'll open the public hearing. Anybody from the public
Report.
wishing to speak? Public hearing's closed. Okay, council comments, or is there a motion on the?
Well, I maintain that the people in Emeryville supported Proposition 215 and therefore would support the establishment of medical marijuana facilities, so I don't agree with the proposed staff direction.
Mayor Atkin, I think Mr. Gein has done an excellent job on this, and I believe the experience of other cities has been very negative with some of these establishments. We have to remember we have a police force that right now is very, very thin, and we're having difficulty recruiting police officers. I think the proposal that Mr. Gein has put forward to us is certainly a reasonable one, and I would move the first reading
Is there a
of the
second?
ordinance.
I'll second.
Please call the roll.
Okay, and I just want to make a comment before we do. I'm being hypocritical here because philosophically, I think probably drug use ought to be non-criminalized. I think it ought to be legal and eliminate the drug wars. And a certain number of people would be lost to society just like they are drinking alcohol. But I think the negative side of the drug wars is terrible. So it's hard for me to support this, but I do, because where I'm being hypocritical is, do I want a dispensary in Emeryville? No. Too many problems. So I know that's inconsistent, but that's the way it is.
Please call the roll.
What's
Councilmember
the issue
Bukowski.
now? What are we voting on? You reading it by
First
title?
reading.
First
Oh,
reading.
okay, no.
Councilmember Davis.
Aye.
Councilmember Fricke.
Aye.
Vice Mayor Cassis.
Aye.
And Mayor Atkin.
Wait, you forgot Ken.
No, he said no.
I said no.
Oh, okay. Aye. Thank you. That concludes our public hearings. And